Hello, everyone. Good afternoon and good morning to some of you. Thank you for joining us for a discussion of the broker deposit and interest rate restriction rules that were approved by the FDIC's Board of Directors on December 15th, 2020, and that become effective on April 1st, 2021. I'm Rayanne Miller. I'm Senior Deputy Director in the Division of Risk Management Supervision of the FDIC. With me today are Tom Lyons, Chief of the Policy and Program Development Section of RMS, Judy Gross, a Senior Policy Analyst in Tom's section, and Vivek Khare, Counsel in our Legal Division. Please turn to Slide 2. Slide 2 addresses the subject we are going to be covering in this presentation. Because of the significant changes in Section 337.6 of our rules and regulations for broker deposits, as well as the new Section 337.7 for interest rate restrictions applicable to less than well-capitalized institutions, we thought it would be useful for you, the industry, to have an overview of these changes. Now, these changes are quite extensive, and we encourage you and your legal advisors and accountants to look and review the rule as well. Today, we're also going to be discussing operational aspects of new notice and application filing procedures, which procedures were established by the revised rule. Please turn to Slide 3. A little background. Slide 3 reminds us that Section 29 of the Federal Deposit Insurance Act imposes restrictions on less than well-capitalized banks, which the FDIC has implemented in Sections 337.6 and 337.7 of the FDIC's rules and regulations. As a very high-level summary of the restrictions set forth in the law, adequately capitalized banks must apply for an FDIC waiver to accept broker deposits. Undercapitalized banks cannot accept broker deposits. In addition, less than well-capitalized banks are limited in the rates they can offer deposits. All of these restrictions remain in effect, although, as we'll see in the next slide and in future discussion today, some of our interpretations of the law have changed. We would also point out that with the April 1st to 2021 effective date of the new regulations, insured depository institutions, which today we'll be referring to them as either IDIs or banks, will begin to report changes, if any, with the way deposits are categorized on the call report in the June 2021 filing. Interagency call report instructions will be released prior to the June 30th due date. And while we'll be answering some questions we have received at the end of our prepared remarks, and we'll endeavor to continue to do so, as with any changes in regulation that also affect call reporting, IDIs are advised to consult with their accountants and legal counsel on reporting treatment. And I would like to remind the audience that well-capitalized institutions can continue to accept brokered deposits without restriction and pay any rates they wish on their deposits as well. So now let's move to Slide 4. So I mentioned previously that on December 15th, 2020, our board adopted a final rule revising the broker deposit and interest rate restrictions in Sections 337.6. The final rule was published in the Federal Register on January 22nd, 2021. You can go there to refer to the final rule, but it's also available on the FDIC's public website and as an attachment to Financial Institution Letter 113-2020. The final rule establishes a new framework for analyzing when a third party meets the deposit broker definition and the primary purpose exception to the definition. More specifically, the final rule clarifies when a third party is a deposit broker by providing specific activities that are captured by the definition. In this way, the rule interprets the primary purpose exception and both, 1, designates a number of business relationships that automatically meet the exception, and 2, provides an application process for entities that do not meet one of the designated business relationships. The rule also explains when non-maturity deposits are accepted and solicited for the purposes of applying the broker deposits and interest rate restrictions that are applicable to less than well-capitalized institutions. In addition, the FDIC moved the interest rate restrictions to a new section, 337.7, and amended the calculation of the national rate and the definitions of the national rate cap and local market rate cap. As I also mentioned, the revised rule becomes effective on April 1st, and that we also will anticipate seeing changes to the way institutions report broker deposits on their call reports via the June 30th call report filing. Now, some parts of the rule have an extended compliance date of January 1st, 2022. And this was done to allow IDIs to continue to rely upon previous advisory opinions or other staff advisory opinions that predated the final rule in determining whether deposits placed to a third party are brokered. This is to provide time, in the event it is needed, for IDIs who are relying on previous interpretations to review deposit arrangements and make changes to their information systems, contracts, or other documents that might be necessary. After January 1st, 2022, entities may no longer rely on these previous staff advisory opinions or other interpretations. It's also important to note that given the significant changes in the regulation, it is likely that the analysis in the advisory opinions will no longer accurately reflect the regulation, even if the conclusion that a deposit is brokered or not may be the same, given changes in the interpretations that were reflected in the regulation. The rule lists the advisory opinions and financial institution letters that will become inactive on that date. It's also worth noting that a number of business arrangements that have previously been viewed by staff as meeting the primary purpose exception have been codified in this rule, and we'll get into that later. Turn to slide number 5. Brokered deposits are defined as deposits placed by or through a deposit broker. Deposit brokers generally include those who are engaged in the business of placing or facilitating the placement of deposits of third parties at IDIs, those selling brokered CDs, those arranging deposits to fund prearranged loans, or, for less than well-capitalized IDIs, the IDI or their employees soliciting deposits by paying interest significantly higher than those offered by other IDIs in the IDI's normal marketplace. One notable change in the final rule to the deposit broker definition is that any person who has an exclusive deposit placement arrangement with one IDI and is not placing or facilitating the placement of deposits at any other IDI will not be a deposit broker. Please move to slide 6. The final rule establishes a new framework for when a person meets the deposit broker definition. The first part of the definition is whether a person is, quote, engaged in the business of placing deposits, end quote. The final rule provides that a person meets this part of the definition if that person has a business relationship with its customers, and as part of that relationship, the person receives funds and then places deposits with IDIs on behalf of that person's customer. The second part of the deposit broker definition is whether a person is, in quote, engaged in the business of facilitating the placement of deposits, end quote. This part of the definition applies to specific situations where the person does not directly place deposits on behalf of customers with IDIs. In the final rule, a person meets the facilitation part of the deposit broker definition if that person has a business relationship with its customers, and as part of that relationship, the person has legal authority, contractual or otherwise, to close the account or move the third party's funds to another IDI. The person is involved in negotiating or setting rates, fees, terms, or conditions for one or more specific deposit accounts, not just working with the bank to determine appropriate rates for accounts generally, or the person engages in matchmaking, which is defined as proposing deposit allocations at or between more than one bank based on both the particular deposit objectives of a specific depositor or depositor's agent and of specific banks, excluding activities conducted between a bank and an affiliated third party. The matchmaking prong captures a very specific activity provided by a person between a depositor or a depositor's agent and a bank. For example, the matchmaking prong will capture intermediaries engaged in, quote, matchmaking activities, end quote, as defined in the rule as part of an unaffiliated deposit sweep program between a depositor, its broker-dealer, and various unaffiliated banks. However, matchmaking prong does not include persons that engage in activities that would otherwise satisfy the matchmaking prong if, and to the extent that, these activities are conducted between a bank and an affiliated third party. The final rule also includes an anti-evasion provision for the matchmaking prong to ensure that third parties do not try to structure a deposit placement in a way that evades meeting the matchmaking definition, while the third party is still playing an ongoing role in providing any function related to matchmaking. Any person, including bankers and examiners, who suspects evasion should report the facts to the FDIC's Washington office of the Division of Risk Management Supervision. Upon a finding by and with written notice from the FDIC, evasion will result in the evading party being deemed to be matchmaking. And I should also point out here that brokered CDs placed by or through the assistance of third parties continue to be classified as brokered under that third part of the deposit broker definition. Please move to slide 7. Slide 7 discusses exceptions to the deposit broker definition. Section 29 provides 9 statutory exceptions to the definition of deposit broker, and the FDIC established one regulatory exception some years ago. While the statute defines most of the exceptions narrowly, most of the questions we receive about exceptions generally have related to the more general primary purpose exception, or what we refer to as PPE. The final rule clarifies that the PPE will apply when, with respect to a particular business line, the primary purpose of the agent's or nominee's business relationship with its customers is not the placement of funds with depository institutions. We have changed our focus for the PPE. The focus is no longer the relationship between the agent's or nominee's relationship with the bank. So even if the bank is paying a third party for the deposits may still meet the primary purpose exception. Turn to slide number 8. In the final rule, in order to provide a bright line for granting a PPE, the FDIC created a list of, quote, designated exceptions, end quote. And these are specific business relationships that automatically receive a PPE without filing an application. The rule then allows agents or nominees that do not meet one of these designated exceptions to apply for a PPE. And I should point out that for 2 of the 13 designated exceptions, the FDIC will require the entity to notify the FDIC that it is relying on the PPE and either provide quarterly reporting, similar to the monthly reporting that's currently done by banks with a PPE that receive deposits from deposits as sweeps from broker dealers under Advisory Opinion 0502, or an annual certification. For the other designated exceptions, no notice, application, or reporting is required. The rule also provides the FDIC the ability in the future to identify additional designated exceptions that will not require an application. Now, either the bank receiving deposits or the agent or nominee placing or facilitating deposits can file a notice or application on behalf of the bank to rely on the PPE. Now, I'm going to turn it over to Tom to pick up with slide 9 for the next few slides. Tom?
All right, thanks a lot, Rayanne. I appreciate that. So please turn to slide 9. So slide 9 digs more into the exceptions and discusses the designated exceptions with respect to a particular business line listed in the final rule. The first designated exception is the 25% test. So this exception applies if less than 25% of the total assets that the agent or nominee has under administration for its customers in a particular business line is placed at IDIs. An example is sweeps of uninvested funds from a broker-dealer where no more than 25% of the broker-dealer's assets under administration are deposited at IDIs. Under this test, the FDIC will no longer distinguish between affiliated and unaffiliated sweep programs to determine whether a broker-dealer or investment advisor meets the primary purpose exception. The second designated exception is the enabling transactions test. A third party meets the enabling transactions test designated exception if it places 100% of its customers' funds that have been placed at IDIs with respect to a particular business line into transaction accounts with the business purpose of enabling transactions or making payments, and no fees, interest, or other remuneration is provided to the underlying customer. Payments made by the bank to the third party are not considered in applying this test. So now we're going to move on to slide 10. The other designated exceptions listed in the rule are self-effectuating and do not require any notice or application. The list includes property management services, certain cross-border clearing services, certain real estate-related transactions, including mortgage servicing, escrow services, and 1031 like-kind exchanges, deposits related to satisfaction of certain regulations, specifically, SEC and CFTC rules. Deposits placed as required collateral for credit card loans, health savings accounts, deposits placed for qualified tuition programs, deposits placed in a retirement account that is not part of an employee benefit plan, and deposits placed by agencies to disperse government benefits. And, as Rayanne just mentioned, the FDIC also is authorized to designate other relationships as meeting the primary purpose exception. Agents or nominees that are deposit brokers but do not qualify for a designated exception may apply for a primary purpose exception. However, some business relationships are not eligible for a primary purpose exception, and these include deposit placements of brokered CDs and deposit placements with a primary purpose of encouraging savings. So note that there is no meaningful distinction between a primary purpose of encouraging savings, maximizing yield, providing deposit insurance, or any similar goal, and a primary purpose of placement of funds with depository institutions, which Section 29 of the Federal Deposit Insurance Act explicitly excludes from the primary purpose exception. However, encouraging savings as part of a specific tax-incentivized government program, similar to a 529 plan, may qualify for a primary purpose exception. So the primary purpose exception applies to specific business lines, so entities should, in good faith, determine their appropriate specific business lines. The FDIC generally will defer to the entity's determination of business lines, but retains the discretion to redefine the business line to which the PPE would apply. The FDIC is more likely to scrutinize the identification of a business line if the business relationships to which it refers are materially broader than the business relationships with a specific group of customers for whom the business places or facilitates the placement of deposits. So even if one party qualifies for a primary purpose exception, the involvement of another intermediary may require that a deposit be classified as brokered. In certain deposit placement arrangements, agents or nominees may use third-party intermediaries to provide administrative functions. If those third-party intermediaries are not defined as deposit brokers, then deposits placed at IDIs from or through an agent or nominee that satisfies an exception to the definition of deposit broker, for example, the primary purpose exception, will not be classified as brokered. However, if the third-party intermediary is, for example, providing matchmaking functions for the agent or nominee and insured depository institutions, then it would meet the facilitation part of the deposit broker definition, and the deposits placed by or through the intermediary would be broker deposits, regardless of the status of the agent or nominee. As is the case today, IDIs remain responsible for proper reporting of broker deposits, so any IDIs that receive deposits from agents or nominees that meet the primary purpose exception should be aware of any other third parties involved in the placement of deposits, and which might meet the deposit broker definition. If such other third parties meet the definition of deposit broker, deposits placed by or through that third party are considered brokered. So please move on to slide 11. So this slide covers the notice and application process for the primary purpose exception. As mentioned previously, certain entities will have to submit notices or applications to the FDIC to invoke a primary purpose exception, and some entities will be required to file periodic reports or certifications. For two of the designated exceptions, the 25% and the enabling transactions business relationships tests, either the third party relying upon a designated exception or the IDI receiving deposits from or through the third party must submit a written notice to the FDIC indicating reliance on the designated exception. Upon the FDIC's receipt of a notice, the third party may rely upon the applicable designated exception for a particular business line, although the FDIC may require the notice filer to provide additional information and may revoke the PPE if the entity does not qualify for or ceases to qualify for the designated exception. Remember, IDIs are responsible for correctly reporting broker deposits in their regulatory call reports, and the involvement of additional parties may result in a brokered deposit designation, even if one of the parties has a primary purpose exception. So entities or IDIs that seek to qualify for the primary purpose exception for a particular business line, but that do not meet a designated exception, may file an application with the FDIC. So now we're going to move to slide 12. So on this slide, excuse me, the rule revised section 303 of the FDIC's rules and regulations to incorporate new requirements for the notice and application process. By April 1st, the Bankers Resource Center on the FDIC's website will include a broker deposit page with instructions for submitting notices and applications with supporting documentation, as well as any required annual certifications or periodic reports. It will also include a question and answer page, the small entity compliance guide, and an email address to submit general questions about the broker deposit or interest rate restriction rules, or questions about the notice and application processes for the primary purpose exceptions. So I'm going to move on to slide 13. So although we are working towards creating a more seamless online process for submitting notices or applications, beginning on April 1st, IDIs or other entities are to submit their notices and applications through the FDIC's secure mail system. The secure mail system will help ensure the integrity and security of the submissions. Those submitting notices or applications must register to use the secure mail, but the process should take less than 5 minutes. Note for IDIs, do not send primary purpose exceptions or applications through FDIC Connect. Primary purpose exception notices and applications are handled in a separate manner through the secure email process I will describe on the next slide. So let's move on to slide 14. The FDIC is creating separate mailboxes for notices, applications, and required periodic reports and annual certifications that are required for the related primary purpose notices and applications. All of the addresses will be listed on the Bankers Resource Center Broker Deposits webpage in the notice and application instructions. Once the filer has entered the FDIC secure mailbox, it should submit documentation to the correct email address. For example, if a filer intends to submit a notice for a primary purpose exception under the 25% test, it would send all the required information designated by the rule using FDIC's secure email to the email address for notices. Once the FDIC has received the notice or application through the secure mailbox, secure mailbox, the sender will receive an automatic electronic response acknowledging receipt. As provided in the rule, notice filers may immediately rely on the primary purpose exception unless and until notified by the FDIC that the notice is no longer active. Application filers may not rely on the primary purpose exception until the FDIC notifies them that their application has been approved. The FDIC will begin its review of applications no later than September 3rd, 2021. The FDIC will send written notice of its determinations for applications submitted on or before September 3rd, 2021 by January 1st, 2022. And that's consistent with the normal 120-day review period provided in the rule. However, if necessary, the FDIC, with notice, may extend the review period. So please be aware that the sensitivity of the filing submissions requires the established secure email process, and this process will only recognize email traffic originated through the FDIC's secure mailbox. If filers do not use the secure email, the FDIC will not receive the submission, and the filer will not receive the automated acknowledgement. Notice filers will not be able to rely on the primary purpose exception until it receives acknowledgement that the FDIC has received its notice. So let's move on to slide 15. So consistent with the FDIC's transparency initiatives, the FDIC will post on the new Bankers Resource Center broker deposit page a list of entities that have submitted notices or have had notices submitted on their behalf by IDIs. The first listing likely won't be posted before at least a few weeks after April 1st, and will be updated periodically thereafter to reflect new notice filings and changes in the status of existing filings. So now that we've summarized the revised rule and the notice and application process, we need to remind the audience of the necessity for banks to operate safely and soundly. Under the final rule, some categories of deposits that have been considered brokered in the past will instead now be considered non-brokered, so that even undercapitalized banks can have deposits previously not permitted because the deposits were defined as brokered. Nevertheless, the banking agencies will continue to exercise their supervisory responsibilities to ensure that banks are operating in a safe and sound manner. Nothing in the final rule impedes the agency's abilities to review or take supervisory action with respect to funding-related matters, including funding concentrations, whether or not classified as brokered, that may affect the safety and soundness of individual banks or the industry generally. So examiners will continue to review the funding structure and sources as part of safety and soundness examinations, regardless of whether or not the deposits are deemed brokered, and will continue to assess whether banks are reporting deposits accurately on their call reports, and if less than well capitalized, complying with the regulatory restrictions. Also, nothing in this final rule changes the FDIC's or the other federal regulators' authorities under Section 8 or Section 39 of the Federal Deposit Insurance Act. With that, I'm going to turn the discussion over to Judy Gross. Judy?
Thank you, Tom. We're now on slide 16. With slide 16, we move to the rules revisions to the interest rate restrictions applicable to less than well-capitalized IDIs. In addition to changes in the definition and treatment of brokered deposits, the final rule moved the interest rate provisions from section 337.6 to 337.7 and revised the deposit interest rate caps applicable to less than well-capitalized IDIs. Interest rate caps on deposits applicable to banks less than well-capitalized had become an issue because they did not seem to be sufficiently reflective of actual current interest rates. As neither the Treasury-based interest rate used before 2010 nor the methodology in effect from 2010 to the effective date of this revised rule works in all interest rate environments, we wanted to create a rate cap that would be durable in both high rate or rising rate environments and low rate or falling rate environments. The change was designed to reflect the prevailing deposit interest rate environments, allowing less than well-capitalized institutions appropriate access to liquidity while continuing to ensure that less than well-capitalized institutions not solicit or accept deposits by offering interest rates that significantly exceed prevailing rates on comparable deposit products. The rule revised the calculation of the national rate by replacing the interest rate average weighted by branches with an average where each institution's interest rate is weighted by its share of domestic deposits. The average also includes credit union rates. The revised national rate cap applicable to less than well-capitalized institutions provides a great deal of flexibility for banks, with the cap for deposits with a maturity date set at the higher of the national rate plus 75 basis points or 120% of the current yield on similar maturity U.S. Treasury obligations plus 75 basis points. For non-maturity deposits, there is no applicable Treasury security to serve as a peg. The FDIC concluded that the federal funds rate, based on overnight deposits, is conceptually closer to non-maturity deposits and set the rate cap for non-maturity deposits applicable to less than well-capitalized banks at the higher of the national rate plus 75 basis points or the federal funds rate plus 75 basis points. Please move to slide 17. Slide 17 addresses the FDIC's change from publishing the national rates and national rate caps weekly to publishing such data monthly. We will be posting a new rates on April 1st, and then it will change monthly thereafter, or approximately monthly thereafter. Please move to slide 18. Slide 18 addresses changes to the local market rate cap. With the increased flexibility in the national rate cap, we expect fewer requests by less than well-capitalized institutions to use the local rate cap. Nevertheless, the FDIC simplified the local rate cap by eliminating the two-step requirement for less than well-capitalized institutions. First, they had to request a high rate determination from the FDIC, and, if approved, had to calculate the prevailing rate within their local markets. Instead, now, the bank is to notify the FDIC and its primary federal regulator that it intends to offer a local rate and provide evidence that a bank or credit union with a physical presence in the institution's normal market area is offering a specified rate on a particular deposit product in its local market area. Evidence could include a newspaper ad or a screenshot of a local bank's ad on the web. The IDI then is allowed to offer 90% of the rate offered by the competing institution in the local market area, where those competing institutions are physically located within the local market area. The IDI would calculate the local rate cap monthly and maintain records to support its calculations. Please move to slide 19. On slide 19, we address the treatment of off-tanner maturity products. If an IDI offers a product with an off-tanner maturity for which the FDIC does not publish the national rate cap, or that is not offered by another institution within its local market area, the rule no longer provides for interpolation or extrapolation of interest rates. Under the revised rule, the IDI must use the national or local rate cap offered on the next lower on-tenor maturity for that product. For example, if an IDI seeks to offer a 26-month certificate of deposit, there is no similar Treasury security maturity. So, if no local institution is offering a 26-month certificate of deposit, the less than well-capitalized IDI must use the rate offered for a 24-month certificate of deposit to determine the applicable national or local rate cap. On-tenor maturities are defined to include the following terms: 1 month, 3 month, 6 month, 12 month, 24 month, 36 month, 48 month, and 60 month. All other term periods are considered off-tenor maturities. There is no off-tenor maturity for non-maturity products such as interest checking accounts, savings accounts, or money market deposit accounts. Please move to slide 20. The new rule clarifies the treatment of non-maturity deposits for purposes of the brokered deposit and interest rate restrictions. There has been a lot of discussion over the years about when the brokered deposit and interest rate restrictions should apply to non-maturity deposits. Under Section 29 of the FDI Act, time deposits are accepted when renewed or rolled over, but the statute is silent about non-maturity deposits. For deposits credited to a non-maturity account, the FDIC is adopting a new interpretation for the solicitation and acceptance of non-maturity deposits. Under this interpretation, and for the interest rate restrictions, an IDI solicits a non-maturity deposit when it opens a non-maturity account, raises the rate paid on a non-maturity account existing when the bank was last well capitalized, or credits funds for a new depositor to a non-maturity account existing when the bank was last well capitalized. For the brokered deposit restrictions, when a less than well capitalized IDI accepts a non-maturity deposit, brokered deposit depends upon the source of the deposit. If the deposit is from a particular deposit broker, the bank accepts the deposit when the deposit broker opens any new non-maturity account or when the deposit increases the aggregate account balance above the aggregate account balance at the time the institution fell to less than well capitalized. If the account is an agency or nominee account, typically an omnibus account, the bank accepts the deposit when it credits any funds for a new depositor to the non-maturity account, for example, by adding an additional customer or beneficial owner to an existing omnibus account. Please move to slide 21. Slide 21 summarizes the rule specification of when interest rate restrictions apply to broker deposits placed into non-maturity accounts. An adequately capitalized IDI with a waiver to accept broker deposits may not pay interest in excess of the applicable rate cap for a particular deposit broker on any new non-maturity accounts or on any balance in the account exceeding the aggregate account balance at the time the bank fell to less than well capitalized. For agency or nominee accounts, this means that an adequately capitalized bank with a waiver to accept broker deposits may not pay interest in excess of the applicable rate cap on any funds from a new depositor, for example, by adding deposits from an additional customer or beneficial owner to an existing omnibus account. I will now turn the presentation back to Rayanne Miller.
Thank you very much, Judy. Please move to slide 22. So we've covered a lot of material in this presentation, but we could summarize the changes as follows. Although the final rule significantly revised parts of Section 337.6 of the FDIC rules and regulations, broker deposit and interest rate restrictions remain applicable to less than well-capitalized IDIs. However, some deposits currently classified as brokered will no longer be classified as brokered. Therefore, adequately capitalized and undercapitalized IDIs will be able to hold such reclassified deposits without restriction under Section 29. Also, even though many deposits that currently have an exemption from being classified as broker deposits will remain exempt, the analyses may be quite different because of the interpretations are very different. Note that a broker deposit waiver from the FDIC is still required for a bank that is adequately capitalized and wants to either solicit or accept broker deposits. Please remember to check the Bankers Resource Center broker deposit page for additional information about the rule and how to submit notices and applications, including the appropriate addresses for such submissions within FDIC secure email. As Tom mentioned, that page will be updated as of the April 1st, 2021 effective date of the regulation. Please turn to slide 23. As we have discussed, changes to the broker deposit rule do not affect the requirements for safety and soundness. IDIs continue to be responsible for proper reporting of broker deposits. Less than well-capitalized IDIs continue to be responsible to comply with 337.6 limitations on broker deposits and 337.7 restrictions on deposit account interest rates. The banking agencies will continue to review funding strategies, risk management practices, and deposit concentrations as appropriate, and will take such supervisory efforts as may be necessary to ensure that banks are operating in a safe and sound manner. We're going to now answer some of the questions we received before this webinar. And as noted earlier, we're also going to be posting a question and answer page on the Bankers Resource Center with responses to some of the questions we have addressed today, as well as to other questions we may not be able to get to or receive separately. Please also note that it is our intent to update the Q&A document periodically based on additional questions that may come up over time. So joining us to respond to questions are Vivek Kare from our legal division, and will join myself and Judy. I might also point out that you may submit your questions to brokered low-dash deposits at fdic.gov. The address is listed in our FIL, Financial Institution Letter, announcing this call. One of the most common questions we've been monitoring as we're conducting this call is, will we provide a replay of this message, of this event today? And yes, we will do so. We will provide a on-demand type of clip for the call today. Our process requires us to make sure that we meet compliance requirements for those who may need assistance. And so as soon as we can get those requirements met, we will certainly post the replay of this call. So let me start with some questions. So I'm going to start with some questions we've received about exclusive deposit placement arrangements. And so the first question was, if a broker-dealer is sweeping deposits only to one IDI, will it need to file a notice to rely upon the 25% designated exception? And I'm going to answer this one myself. No. A third party that has an exclusive deposit placement arrangement with one IDI is not a deposit broker under the deposit broker definition, and so it would not need to rely upon any of the exceptions or file a notice or application for a primary purpose exception. However, if the third party currently has a primary purpose exception, for example, one of the entities that has a primary purpose exception under Advisory Opinion 0502 for sweep arrangements, to avoid confusion, it would be useful for that third party to inform the FDIC that it will no longer be submitting monthly statistics because its broker-dealer has an exclusive arrangement with the bank. So I'm going to move on to the second question in this exclusive arrangement section. The question is, if an IDI has separate affiliates that each sweep funds to the IDI and do not sweep to any other IDI, would each of the affiliates be considered to have an exclusive deposit arrangement with the one IDI? And I'm going to turn this one over to Tom Lyons to respond.
Hey, thanks for that question, Rayanne. The answer is yes. For how you described it, it would be an exclusive deposit arrangement. If each affiliate is placing funds at only one IDI, then each affiliate would have an exclusive deposit arrangement and would not be classified as a deposit broker. Thanks.
Thanks very much. So we've also gotten some questions about institutions or from institutions and those dealing with institutions that have are existing primary purpose exceptions under the existing interpretations. So I'm going to move on to those questions relating to existing PPEs. So the first question is, how does the new rule affect banks with existing PPEs? For example, in some cases, institutions currently are sending in monthly information and the FDIC is sending back an acknowledgement letter. Is this process for existing PPE exceptions going to change? And I'm going to turn this over to our colleague Vivek Kare to answer this one.
Thanks, Rayanne. So currently, institutions that are relying upon staff advisory opinion 0502 for a primary purpose exception that applies to its affiliated broker dealer operating under a deposit sweep program They may be providing monthly statistics currently to their case managers. Now, the revised regulation will be effective on April 1st, and so we would certainly anticipate receiving those monthly numbers through that period of time until the rule is effective, which I know is just a couple of weeks away, and until a notice has been filed in reliance of one of the applicable designated exceptions. If the institution wishes to continue to rely upon the advisory opinion for sweeps between affiliates and its underlying conditions, it may do so through the full compliance period, which goes up until January 1st, 2022. If the institution chooses to submit a notice in reliance on one of the designated exceptions, they may do so beginning on April 1st. And after submitting the notice, entities or banks submitting the notice on behalf of third parties would then send reports. And so, for example, if it's a 25% test, it would be, a report every quarter. They would send those reports in pursuant to the notice instead of any current monthly statistics that some of the institutions are providing.
Thanks very much, Vivek. And I have a follow-up question to this. Would that institution then need to submit an application starting April 1st, 2021 and switch to quarterly reporting?
So as a reminder, the notice is required for 2 of the 13 designated business relationships provided by the rule. The other 11 designated exceptions are self-effectuating. And so if you would like to invoke a primary purpose exception, but do not meet one of the designated business relationships that either are self-effectuating or require a notice, then you may submit an application for the primary purpose exception. And so to answer the question though, Rayanne, assuming that the entity wants to rely upon a designated exception for the 25% test, it would need to submit a notice, not an application. And as we had discussed during the presentation, the institution can continue to rely upon the previous advisory opinion up until the end of the year, at which point, in order for the institution to rely upon the 25% test, they would need to submit a notice and start to submit quarterly reporting after the FDIC is in receipt of the notice. I'll also add that the rule does set out some specific information that is required as part of the notice. And so entities that wish to rely upon one of the 2 designated exceptions that require a notice should reference the instructions that will be coming up on our FDIC Banker Resource Center to ensure that the notice submission includes all of the necessary components and parts that are provided by the rule, and they will all be listed out in the instructions.
Thanks very much, Vivek. And we've got another question in this area, and I think I'm going to aim this one at Tom Lyons. So Tom, if a third party wants to rely upon a designated exception that requires a notice submission, so not those self-effectuating exceptions that Vivek just referred to, but for example, the exception for placing 25% or less of its customers' assets under administration at banks. When may it and the bank receiving deposits begin relying on that exception?
Okay. All right. Thanks, Rayanne. So with regard to notices, just want to make sure my camera's on. With regard to notices, the FDIC has established an interim electronic process for the receipt of notices. I talked about that before. So the instructions for the process will be available at the FDIC's website at fdic.gov. The Bankers Resource Center broker deposit page, and that'll be up by April 1st. And it'll include instructions for using the secure mailbox and email addresses for the notices and for applications. So a notice that is submitted through the electronic process, will be acknowledged upon receipt via a return email. So entities may begin relying upon the primary purpose exception immediately after receipt of the return email acknowledgement, unless and until the FDIC notifies the filer that they are not eligible for a primary purpose exception. So.
Thank you very much, Tom. And I think we're going to continue on that theme about notice filing and the types of information that is required. So the question is, if a third party or IDI submits a notice, but the FDIC requires additional information, how will that party know what's needed? Turn that to
so that's it. Oh, sorry about that, Rand. I think that's a good question. Right? So the good one for us to clarify. The FDIC will review the notice submissions to determine whether it includes the relevant information for the applicable designated exception. So if the notice requires additional information, staff at the FDIC will contact the filer electronically to make the specific request, and will identify what we need. If the FDIC learns that the entity does not meet the criteria for the designated exception, or that the information provided in the notice was incomplete or inaccurate, the FDIC may, with notice, revoke the entity's primary purpose exception.
My father kept a Finnish woman in his house. Tall and skilled at weaving lovely things.
Okay. Rayanne, back to you.
Rayanne, you're muted.
Okay.
Sorry, folks.
I'm sorry, but I had a slight
problem. Judy looks like she might be having some problems. So Judy, just stand by. So the next question is on non-maturity deposits. So for non-maturity deposits, when is a less than well-capitalized bank restricted from paying rates above the rate cap? And Judy, if you are available to speak, please answer that. If not, we'll pitch in and help you.
I'm available now. I just had a slight computer mishap. Less than well-capitalized institutions are restricted from soliciting deposits by offering rates in excess of the applicable rate caps. An institution solicits a non-maturity deposit when a non-maturity account is open, or the institution raises the rate being paid on a non-maturity account existing at the time when the institution was last well capitalized, or funds for a new depositor are credited to a non-maturity account existing at the time when the institution was last well capitalized.
Thanks very much, Judy. We're going to move a little bit to interest rate changes. So I think I'll answer this one as a relatively straightforward one. So under the revised rules, to which institutions do interest rate restrictions apply? So the interest rate restrictions apply to all IDIs that are less than well capitalized. So this is not a change. This has been always the case about interest rate restrictions. They have always applied to IDIs that are less than well capitalized. And it's important to note that Section 29 does not now and never has provided a waiver for the interest rate restrictions that are applicable to less than well capitalized institutions. So I'm going to move to the next question. And I think this is in Judy's wheelhouse. So Judy, what national rates would be used for a 13-month CD since it is an odd maturity?
Thanks, Rand. If an institution seeks to offer a product with an off-tanner maturity for which the FDIC does not publish the national rate cap, or that is not offered by another institution within its local market area, then the institution will be required to use the rate offered on the next lower on-tenor maturity for that product when determining its applicable national or local rate cap. And remember, we're only talking about less than well-capitalized institutions here. As stated in the presentation, we no longer allow IDIs to interpolate or extrapolate interest rates on deposit products. In the case of the 13-month secured CD, there is no Treasury security maturity of 13 months, and therefore the FDIC does not publish a rate for that maturity. So in response to the question, the IDI would be able to use a 13-month rate only for purposes of the local rate cap, and only if the 13-month CD is offered by another institution within its local market area. Otherwise, the institution would use the 12-month CD for the national or local rate cap. And notice they can still offer the 13-month CD, it's just they have to use the 12-month CD rate cap.
Yes, Judy, and I did appreciate your clarification that when we're speaking about rate caps and rate restrictions, it helps to remind people that these are only applicable to less than well-capitalized institutions. We sometimes sound like a broken record, but we want to make sure that people understand that's what the law requires. So, Tom, this is the last of our prepared questions. We did get some questions relating to reciprocal deposits. And, the common question and the common theme is, will the treatment of reciprocal deposits change under this rule? So, Tom, maybe I can ask you to answer that one.
Sure, Ann. So, the short answer is no, right? But we need some a little more color for that. So the statutory changes related to the reciprocal deposits, predated this effort that we're talking about today. So back in 2018, there was legislation that was passed that exempted reciprocal deposits from being classified as broker deposits up to certain limited caps, which generally are the lesser of 20% of total liabilities or $5 billion. So to the extent that an institution is receiving reciprocal deposits over those caps, then those would be reported as broker deposits. So this rulemaking doesn't change anything related to the definitions that were provided as part of the 2018 legislation, and the interpretations provided in the final rule that the FDIC adopted on the reciprocal deposit aspect of the broker deposits regulation. So I think that hopefully that clarifies the question related to reciprocals.
Thanks, Tom. Thanks very much. So that's sort of the end of our questions. I wanted to thank you all for logging today and leave you with some reminders. We did cover a lot of ground today, and this won't be our last communication with the industry. As we mentioned today, we will be adding the Bankers Resource Center broker deposit page on the FDIC website on the April 1st effective date of this regulation, and that's going to be a great resource for you. It will have links to the law, the regulations for broker deposits, and interest rate restrictions that are applicable to less than well-capitalized institutions. And, we wanted to remind you and your advisors that the preamble to the revised regulation really does give a lot of explanation and examples. We actually used examples in there. When we're dealing with interpretations, it's very difficult to arrive at every single interpretation for every single arrangement, but there are a lot of great examples that you can refer to in the preamble. We'll also be publishing a small entity compliance guide, which will be hopefully a sort of shorthand way to explain the rule. The webpage will also include, as Tom was mentioning in his remarks, the complete instructions for submitting notices and applications related to the primary purpose exception. It will be there'll be complete instructions for using the FDIC secure mailbox and the email addresses that are separate for each of the notices and applications, and then for any of the required quarterly reports or annual certifications. And we wanted to remind folks, it bears repeating, that notices and applications must be submitted through the secure mailbox, not through FDIC Connect or to other FDIC offices. That will slow down your action. And we're certainly working on a more seamless automated submission process. And when complete, we would issue communication to the industry about that and post instructions on the broker deposit page. Also included in this broker deposit page on our website will be an address for submitting questions regarding broker deposits, including any questions folks might have about the primary purpose exception requirements and the operational processes around that. We mentioned that we'll have a questions and answer page up there, which we will update periodically. So as I mentioned, we're going to have that page out before the or on the effective date. So that'll be up soon, and watch for the financial institution letter that will announce that. Also important to remind you that the national rate caps and local rate caps that are applicable to less than well-capitalized institutions will also change on April 1st. And we're also going to be changing the cadence with which we report those. So we mentioned this in the meeting, but I think it's important to remind folks that it used to be a weekly reporting, and we're now going to generally update the rates every month. And so we think that the revised broker deposit and interest rate restriction rules are going to provide institutions with great flexibility and transparency about what's considered a primary purpose exception in particular. And so we look forward to launching the new processes on April 1st and working with all of you to do that. So with that, we wish you a happy rest of your day, and please feel free to submit your questions to us on our website. Thank you very much. Good day.